So, you've been injured in an accident in Scotland. Your mind probably jumps to a dramatic courtroom scene, right? Lawyers, a judge, the whole deal. Well, what if I told you the reality is completely different? Today, we're going to pull back the curtain and show you how personal injury negotiations really work.
Okay, first things first, let's just get the whole TV drama image out of our heads. We all picture this tense, public showdown in a courtroom. But the reality for the vast majority of personal injury claims, it's actually a quiet, really structured negotiation that's handled almost completely in writing between the legal teams. No shouting matches, I promise.
So that naturally leads to the big question, right? If it's not like the movies, then how does this whole process actually unfold? And maybe even more importantly for you, what's your part in all of this? How do you make sure you get the best possible outcome? Well, that is exactly what we're about to break down. Okay, so here's our roadmap for today. First, we're going to hammer home why you need to forget the courtroom drama. Then, we'll get into why evidence is absolutely everything. After that, we'll walk through what we're calling the negotiation dance. We'll also cover a couple of major game changers you need to know about. And finally, we'll talk about your crucial role in making it all a success.
All right, let's dive into part one. Forget the courtroom drama.
So here is the single most important thing to get your head around. Your claim will almost certainly be resolved through this back-and-forth written negotiation, not by a judge banging a gavel. Seriously, just understanding this one fact is the key to demystifying the entire experience. It lets you approach it with confidence, not anxiety.
And that brings us perfectly to our second section, why evidence is everything. Because before a single offer is even thought about, you have to build a rock-solid foundation for your claim.
And this is where we need to put up a huge red flag. Rushing into a negotiation is a massive mistake. Why? Because a settlement is final. That's it. You can't go back in a year and ask for more money if it turns out your injuries are worse than you first thought. And that's exactly why getting the evidence right from the very beginning is absolutely non-negotiable. So, what does building that foundation actually look like? Well, your solicitor follows a really clear, methodical process. First, they get a detailed medical report. Then, they prepare a full financial schedule of every single loss, things you've already lost and things you might lose in the future. They establish exactly who is at fault, and only after all of that is done do they determine a valuation range for your claim. And look, this valuation, it isn't just a number someone guesses or plucks out of thin air. It's a professional assessment, and it's carefully calculated using official guidelines, data from thousands of similar cases, and of course, the very specific facts of your situation. This gives you a strong, evidence-based framework for the entire negotiation to come.
All right, so once all that evidence is locked in, we can finally get to Section 3, the negotiation dance. This is where the back and forth really begins.
So, your side gets to make the opening move. This happens with a formal document called a letter of claim. This letter lays out all that evidence we just talked about, and it states the full value of your claim. You can think of this as your opening position. It represents the top end of the reasonable range that your evidence can support.
Okay, now the insurer is going to come back with their first offer. And this is so important. Do not be discouraged. This first offer is almost always a deliberately low opening bid. It's just a standard negotiating tactic. They're trying to anchor the whole conversation at a lower point. It is not their final position. It's just the start of the dance.
So you can kind of picture how this whole back and forth works, right? You start high, but it's a high number based on solid evidence. They start low, pretty much as a tactic. Then, through a series of written counteroffers, that big gap between the two positions starts to get smaller and smaller. With each step, both sides move a little closer to a potential settlement figure somewhere in the middle. But, it's not always that simple and straightforward. In Section 4, we're going to look at a couple of factors that can totally change the game. First up, what happens if the other side says, hey, wait a minute, you were partly to blame for this? Well, this is a legal idea called contributory negligence, and it adds a whole new layer to the negotiation. Suddenly, you're not just arguing about the total value of the claim, you're also arguing about the percentage of blame. And that makes a huge difference. For instance, if they argue you were 25% at fault on an $80,000 claim, that's a $20,000 difference right there. The stakes get a lot higher.
Now, the second big game changer is something really specific to the Scottish legal system, and it only comes into play once a case actually goes to court. It's called a tender. And this is not just another offer. It's a formal, high-stakes strategic move, and rejecting it can have some pretty serious financial consequences.
So what makes a tender so serious? Well, here's the deal. If you reject a tender, and then your case goes all the way and you win in court, but for less than what the tender offered, you could be forced to pay the other side's legal fees starting from the day they made that offer. That could literally wipe out your entire compensation award. It forces you to make a really tough, calculated decision about risk versus reward.
Okay, which brings us to the most important part, really, our final section, your role in success. With all of these moving pieces, what is your job in all of this?
Look, your solicitor is the one doing the day-to-day back and forth, but the big calls, they come down to you. Your job is to give them clear instructions, to really listen to their advice, and to make informed choices. Probably the most common mistake people make is letting impatience push them into accepting a low offer too early. You have to trust the process, trust the evidence, and always remember, your solicitor is there to advise you, but the final decision is always yours.
At the end of the day, it really all boils down to this one simple idea. Knowledge is power. By understanding how this structured evidence-based process actually works, you can replace all that anxiety with genuine confidence. It means you can have meaningful conversations with your solicitor and make the absolute best decisions for your future.
So we'll just leave you with this thought. Now that you've had a look behind the curtain, now that you actually understand how this process really works, what is your next informed step going to be?